Good morning, everyone. Good morning, everyone.
Good morning.
I'd like to call the Door County Board of Supervisors to order on Thursday, September 27th at 9 a.m. Would you please rise and join me in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call.
Come on. Say it a minute.
Yeah, we're skating.
What does that say? Don't feel bad. Like,
Where'd he go?
Yes.
there we go.
We have 21 present. Presentation of the agenda.
Move to approve.
Second.
All in favor?
Aye.
Opposed? Correspondence. We're going to move to public comment. For public comment today, everybody is welcome to speak. I would ask that if it's on the same subject that it not be repetitive. I'd also like to limit it to 3 minutes. However, I am willing to allow you to say whatever it is you would like to say. So whoever would like to start.
Barbara Grau, 354 South 15th Court. I'm speaking on behalf of the League of Women Voters. For decades, the League of Women Voters has studied, developed positions, and taken action to support efforts to protect water quality. We know that Door County is a place where our karst geology and shallow soils make us particularly vulnerable to groundwater contamination. Evidence has shown that the current DNR rules governing how certain aspects of our agriculture are managed are not sufficient to protect the groundwater in our area. We appreciate the collaborative nature in which the NR 151 standards were developed, with sensitivity to the needs of the farmers while keeping the rights of all Wisconsin citizens to have clean water on the forefront. The League of Women Voters of Door County encourages the Door County Board of Supervisors to support the revisions of NR 151. Thank you.
Thank you. Anybody else? Good morning. Yes, that's fine.
Good morning, ladies and gentlemen of the County Board. My name is Casey Yankee, and I'm the Deputy Sheriff with the Door County Sheriff's Department, currently assigned to the Jail Division for the last 5.5 years. I'd like to go over 3 topics this morning that relate to me and the Sheriff's Department and this county. First, I'd like to talk about my education and my background, and then I'd like to talk about what brought me here to Door County. And then I'd also like to talk about my future aspirations here with the Sheriff's Department. I'm originally from Green Bay. I'm a 2006 graduate of Bayport High School. I'm a 2009 graduate of the University of Wisconsin Green Bay, where I double majored in political science and public administration. I served 8 years as a firefighter for the Howard Fire Department, and I served 12 years in the U.S. Army. While on a deployment to Afghanistan, serving as a civil affairs team leader at the rank of first lieutenant, I made the choice that I wanted to pursue a career in law enforcement. I enjoyed my time in public safety very much from the military and from my time being a firefighter. In Afghanistan, I decided that I was going to enroll into the Summer Academy 25 session at NWTC in Green Bay, where I eventually completed that as the top of my class. I was a valedictorian of it, and I knew that I wanted to stay in Northeast Wisconsin because that was my home. I had 3 departments that were at the top of my list. Door County was 1, Ashwaubenon was 2, and De Pere was number 3. About a year into my employment here with the Sheriff's Department, after receiving that phone call from then Sheriff Terry Vogel, I accepted the job, and about a year later, I was offered a job with the De Pere Police Department. I turned that job offer down, and the reason I turned that job offer down was because this county made a commitment to me, and I wanted to make a commitment to it, and I've done so for the last 5.5 years. My future aspirations with this department, it was my understanding that being hired here, we were going to be protected, and that by being protected, it would offer us the opportunity to go to the road when our seniority came to that point. It is my goal to become a patrolman for this department, and I want to continue on with my education. I want to continue on with being a law enforcement instructor, which I have done already in the jail. I'm currently a POSC instructor in the jail, which is our principles of subject control, and I review all use of force incidents in the jail. I also have served as an OIC on the afternoon shift, and I want to continue my career as a patrolman. I want to become a DAT instructor, defense and arrest tactics instructor. I want to become a firearms instructor, and I eventually want to move up the ranks. But I want to make this place my career. I want to continue my commitment to this department and to this county and to its citizens the way that you have all treated me thus far. Thank you for your time.
Thank you.
Good morning. My name is Bobby Gilson, and I just wanted to tell you about how I learned about Door County and wanted to work here. When I was working in Oconto County, we got approved to build a brand new jail, and during that time, we were all assigned multiple different county jails to look into and kind of learn about their functions and how they ran. So during that time, we came to Door County to take a tour, and I can tell you that Door County Jail and the way it is ran outshines most of the jails in Wisconsin, if not all. With the deputies and how professional they are and educated, and how their morale is high, and how highly they spoke of their department, it's not like that with any other jail. And I get saving money is important, but at the same time, is it more important than bringing in educated deputies and people that love their job? So I believe that is why the educated deputies that you have stay, because it is competitive and the pay is high and it really helps with everything. So I believe that is why it's so professional at Door County, because everybody stays there after they come. While going to other county jails, you don't see the deputies there have such positive feedback about their department like they do in Door County. They don't get treated as well, and they're not as educated as we are here. So I just wanted to say that is what brought me here. And I feel like taking away the protective status, we might not bring in as many educated people. And a lot of people might leave just to have that competitive that we did have here and still do and hope to keep. Thank you.
Thank you.
Hello, my name is Blake Lupker, and I'm a deputy sheriff in the jail. Not only am I an employee of this county, but I am also a husband and a father of 2 daughters. I was previously a corrections officer for Brown County Sheriff's Department and served for 8 years. When our protective status was taken away from us in 2013, it was detrimental to the department. From 2013 to now, the department has lost approximately 105 officers. The loss of staff created excessive overtime, lack of morale, and a hardship for the officers and their families at home. Protective occupations is defined as the occupations whose principal duties involve ensuring the public safety and which subject the individual filling the position to periods of great mental and physical stress, require the individual to be present under very dangerous situations, and require the individual to carry out his or her duties regardless of the risk involved. I came to Door County because the protective status is still in place. Every day we deal with criminals and are subjected to dangerous situations that we must act upon. Your decision today does not only affect the jail deputies in this room, but also affects their families, the Sheriff's Department, and the residents of this county. Thank you.
Thank you.
Good morning, ladies and gentlemen.
Good morning.
My name is Mark Schwartz, and I've been a sheriff's deputy with Door County for approximately 26.5 years. I was born and raised in Door County, graduated from Sebastopol High School, went to college, and decided I wanted a career in law enforcement. In March of 1992, I was very fortunate to be hired by Door County. The first 2 years of my career I spent in the jail. I have 20 years in patrol. In the last 4.5 years I've spent in court security. And before I came up to court security, I was in the same boat as you folks. I didn't know a whole lot about the jail or the day-to-day operations of the jail. On patrol, when you arrest someone, you bring them to the jail, you fill out your paperwork, you turn that subject over to the jail, and you leave. And that's pretty much your interaction with the jail. When I came up to court security, I had access to the jail incident and report logs, and I read those. And it really surprised me about what is actually going on in our jail. And I came to a conclusion. Criminals don't take a break when they're in jail. They still commit crimes or attempt to commit crimes. Some of these crimes and incidents that I have either helped respond to or have read about in our jail reports are physical violence or threats of violence against other inmates and also jail staff and jail deputies, suicide attempts and threats of suicide, theft of commissary, theft of phone PIN numbers, absolute sobriety violations by Huber inmates, and on top of that, the health or the mental health issues that are rising in the jail. And these investigations in the jail are not easy because they are criminals. Inmates do not want to be snitches or be a tattletale on someone that they share the same cell block with for fear of some type of retaliation. And some of these investigations are not criminal in nature, but could become so if no action is taken by a jail deputy. And these investigations are very similar to a patrol deputy's objective, which is to prevent crime. And yes, the jail has their slow days and their busy days, just like patrol. It's no different. I think the reason we don't understand what goes on in the jail is because unless it's a major crime, like the murder for hire plot in our jail earlier this year, these incidences don't end up in the paper and for the public to read and be aware of. And I think that is what is the most frustrating for you folks here today, is what goes on in the Door County Jail. Not Chippewa County or any other county, but Door County. I've given you some food for thought before you make your decision today. And I'm not sure who else is going to speak, but I urge you to listen to the people who have been in the trenches and have been there and done that, because they know what they're talking about. As I said, my position right now is court security. I'm not going to talk to you about that because Lieutenant Sterner will get into that when she talks. But I do have a letter that was drafted by the Honorable Judge D. Todd Ehlers and signed by the Honorable Judge David L. Weber that they wished for me to read to you folks in regards to the court security position. Dear board members, it is our understanding that the Door County Board of Supervisors is considering a resolution to reclassify the Door County Sheriff's Department 2 designated court security deputies as not protective occupation participants for the purpose of the Wisconsin retirement system. Since all court operations and related offices relocated to the Justice Center on South Duluth Avenue in November of 2005, the Door County Sheriff's Department has assigned 2 of its sworn deputies as court security officers. Wisconsin Supreme Court Rule 68.07 provides as follows, and that is in regards to security and personnel. Pren 1, courtroom. There should be no fewer than 2 sworn officers in each courtroom and each court commissioner's hearing room when court is in session. The judicial officer may expressly direct otherwise. Pren 2, public entrance staffing. The public entrance should be staffed by at least 1 sworn officer armed with a triple retention holster and access to law enforcement mobile radio, and other qualified court security officers are as necessary. At least 1 sworn officer should be available to patrol the public area and assist with public entrance staffing as needed. The comment to the Supreme Court rule section provides as follows, and I quote, "The presence of sworn officers serves as a deterrent to violent outbursts and provides the ability to respond to incidents that may arise. In this respect, the open and obvious presence of uniformed officers is an example of basic court security principles designed to deter those intent on harm, detect those who have breached security, and limit the damage of that breach. It is impossible to predict the type of case that might lead to a violent incident. Therefore, it is essential to provide court security for all types of cases. The National Center for States Courts Steps to Best Practices for Court Building Security considers the presence of sworn officers at the public entrance an extremely important area of security, and it provides a foundation for the implementation of additional security measures throughout the court facility." Unquote. It is our understanding when we are deciding upon whether Door County Court security officers should be classified as protective occupation participants for Wisconsin retirement system purposes, it must be considered whether their principal duties are active law enforcement. Active law enforcement has been interpreted to include being actively, currently, and directly involved in detecting and preventing crime and enforcing laws or ordinances of the participating employer. It has been our mutual observation and is our belief that our court security officers are in the front line of providing the backbone of our security system at the Door County Justice Center. These officers provide the monitoring of each and every member of the public who come into the building. They protect the building from security breaches and are trained and prepared to limit the damages of any such breach may cause. The protection our court security officers provide is not limited to court staff and the other county employees in the Justice Center. The security they provide benefits other members of the public in the building, attorneys, prosecutors, witnesses, victims, and jurors. Our court security officers are armed and ready to respond to any security situation or unlawful criminal behavior. We have both been witnesses to incidents where they have had to physically restrain litigants and individuals who have been out of control. Our court security officers are responsible for managing incarcerated individuals who are participating in court proceedings. Once an incarcerated individual leaves one of the holding cells in any of the courtrooms, they're in a public area of the Justice Center. The court security officers are responsible for ensuring that security and that peace is maintained. The presence of our court security officers is not limited to criminal proceedings involving incarcerated individuals. Their presence in family matters, domestic abuse injunction proceedings, and other high-tension civil matters is equally essential to maintaining the peace and providing a calming atmosphere. They provide the bulwark for situations that could easily and tragically deteriorate very quickly. Our court security officers also serve an essential duty of monitoring criminal defendants when in the building and their compliance with non-monetary bond conditions. That includes monitoring those individual compliance with absolute alcohol sobriety conditions, and no drive conditions if they do not have a valid driver's license. These officers are actively involved in detecting and preventing additional crime. Our goal in this letter has been to provide you, the members of the Door County Board of Supervisors, with our personal observations and impressions of the duties and responsibilities that our two court security officers provide to not only the employees and staff of the Door County Justice Center, but to the public at large. Thank you for your time and consideration of this information. Yours truly, D. Todd Ehlers, Door County Circuit Court Branch 1, and David L. Weber, Door County Circuit Court Branch 2. And I too thank you very much for your time and just some information for you to make your decision on. Thank you.
Thank you.
My name is Ron Lang, and I'd like to speak to the board today. I don't represent any group or organization, not part of, these officers here. Mr. Lino, I sent you a letter via email. I didn't receive any response, so I'd like to read it here today. I believe you are my representative in Door County Board of Supervisors. My address is 2010 Highview Road, Allison Bay. I believe this puts me in District 20 according to the map provided online. It's not a very good map. I am a longtime resident of northern Door County, living at the current address since 1980 and residing and working in Door County since 1977. I was a social studies teacher at Gibraltar High School from 77 to 2003 when I retired. While Act 10 came after my retirement from teaching and did not affect me directly, it is now affecting me as well as our community in different ways. By attacking collective bargaining at all levels, reducing job status and classification under the guise of saving taxpayers money, you may actually be putting the community you represent at greater risk and cost. If our law enforcement system in Door County is operating efficiently and in a high standard, why would you even consider changing that? I believe removing jailers from protective status to be a huge mistake if carried forth. The world and environment we live in today is not Andy of Mayberry. The people in law enforcement at all levels, including jailers, should at the very least be in protective status. If you move forward with this, who will be next? Firefighters and EMS? Let's stop this nonsense now and keep the very professional, efficient, and effective protective services we have in Door County and be an example for the rest of what Wisconsin can be. I'd like to add, when I was teaching the last couple of years that I taught, I had a group of girls in the current issues class who did a project on affordable housing. They went and talked to every village and town, and if we're going to keep people, young people like some of the people that spoke here today in our community, and you're going to diminish their job status to whatever, pay them what you would pay somebody to clean a motel room or something like that, which is honorable work. Probably they're not paid enough either, but I think that's a huge mistake, and this is all, it's all tied together. I thank you very much for hearing me today, and hope you make the right decision.
Thank you. Good morning.
Good morning. My name is Kyle Baser. I represent the Door County Deputy Sheriff's Association as Association President. We could have deputies from our department continue to speak, but I think you have gotten more than enough information relating to how devastating this could be for the Sheriff's Department. This has been proved by all the deputies you've heard and the letters you've read over the past 2 months. These deputies don't only come from the jail. They come from various divisions of the entire Sheriff's Department. They are deputies that have started in the jail, worked their way up through the ranks, ultimately knowing and remembering that the jail is a core division of this department and is where we began our careers in Door County as deputy sheriffs. These deputies are not in it for themselves, though it may seem like more of a personal gain for them. They're in it for their families, their livelihood, what they signed up for when they were hired 5, 10, 20, 25 years ago. To take something away from them that has been a part of the way they live and what they have worked so hard for is reckless. I myself have been part of this department for 12 years, having left Sturgeon Bay Police Department for a career with opportunity. I have held many positions within the Sheriff's Department, including jail deputy, jail sergeant, and currently patrol deputy. I also am currently one of the lead instructors for jail-related topics within the jail, along with the jail's correctional emergency response team leader. I know I would not be here speaking today had Door County Sheriff's Department not been a protected agency back in 2006 when I was hired. I would have been looking for an agency with opportunity, stability, and most importantly, assurance that my family knows if something, God forbid, would happen to me in this dangerous career I chose, we would be able to continue our lives in a structural manner. Please listen to what you hear today from these deputies, their families, and law enforcement community, and make a decision not on what you're being told what will save money, but on what is right for those who protect and serve you and your families every day. Thank you.
Thank you. Good morning.
Good morning. My name is Mark Bartles, and I'm representing the Door County Deputy Sheriff's Association. I'm filling in for TJ Perrins, who's on vacation. And I'm here today to recap some of the things that TJ talked about in the letter that he sent to the board. It was dated September 13th, 2018, and it had a lengthy letter and some materials. Unfortunately, it's got a lot of legal points, and I'm here to address some of those legal points, and I apologize for that in advance. But we're asking the board to vote against the proposal to change the status of the deputies that are assigned to work in the jail from protective occupation participant status to non-protective status. And I'd like to thank you for the opportunity to address the board. The first point I'd like to make is that this is the board's decision to make alone. The decision to classify the deputies assigned to the jail as protective status is a decision that the board makes on its own. If you choose to keep the deputies in protective status, that's up to you. It's your decision. The county is not currently being looked at by the state or by any agency and being told that it's in violation of any kind of ordinance or statute. It's not. You have the option to keep things the way that they are. No agency has notified the county that it's in violation of any rule. And I think it's been since 1975 that the deputies assigned to the jail have been classified as protective status. The jobs of the deputies have not changed, so why change their status now? So we believe that the deputies assigned to the jail should be considered protective occupation participants under, and it's section 4002, 48A and AM and 3B or B3, and if you agree with that, then they're entitled to protective status. The deputies assigned to the jail are sworn deputies. Their principal duties involve active law enforcement. They are exposed to frequent high degree of danger and peril, and their duties require a high degree of physical conditioning. The Door County model works, and Door County has a long tradition of hiring qualified deputies that are capable of working on patrol, in the jail, and in investigations. All of the deputies of Door County are sworn deputies. There's no difference in the qualifications to be hired whether you're working on patrol, investigations, or in the jail. Throughout the careers, all the deputies are subject to the same physical conditioning requirements. But it just happens that some of the deputies are assigned by the sheriff to work in the jail. The sheriff, I've heard, I did watch your meeting last month, and it was, you all look good on TV. But the sheriff has found, and he told you that the jail is a good training ground, and starting deputies there is a good place to have them train. But it's also good to have deputies be able to move from the jail to patrol, to investigations, and if their circumstances warrant, to move back from patrol into the jail. What a great system. The sheriff has the ability to assign a deputy to different positions based on their need. And the definition of deputy sheriff in section 40.02, 48B3 makes it clear that a qualifying employee remains a deputy sheriff, even if they're temporarily assigned to different tasks. Hiring qualified deputies that can cover all of your needs and the flexibility to assign them where they're needed. That's the Door County model that has been successful for so many years. Maintaining protective status for deputies assigned to the jail is going to ensure that that model continues for years to come. Excuse me. Now, there's been some case law presented, and this is where we get into the heavy lawyer stuff, but the county administration has provided the ETF case, I'll call it, and that was in your materials that you received last month. And that case had to do with 5 jail employees from a different county, not Door County. And those jailers did an extremely poor job of showing why they met the requirements to be in protective occupation status. They failed to show that they were involved in law enforcement activities, that they were exposed to danger, and that they were required to be in good physical condition. We provided in TJ's letter, there was a case from Winnebago County where it was specifically decided that those deputies assigned to the jail could be in protective status. So the ETF case is not, it did not come down from the Supreme Court. It is not a ruling that is bound by everything, by everyone. It's a decision that applies to those 5 deputies and the case that they made in that case, and they didn't do a very good job. The Winnebago County case is closer to Door County if you compare the job descriptions. So the facts of the ETF case are distinguishable from Door County, and that's an important point. The ETF jail employees failed to show that they were sworn deputies. Nothing in that case mentions that they are sworn deputies. In fact, they're continuously called just jail employees. Here, of course, all our people that work in the jail are sworn deputies. In the ETF case, they're just strictly jailhouse employees. The jail employees in the ETF decision failed to show that their principal duties involved active law enforcement. They didn't show that they worked on the SWAT team or in any other deputy duties. In Door County, the deputies are assigned and are eligible to be on the SWAT team, the CERT team, snowmobile patrol, boat patrol, and they can work festivals in the county as crowd control. The jail employees in the ETF decision didn't show that they did investigations. They didn't write citations, or at least they didn't show it. And they didn't show that they made referrals to the district attorney for criminal charges. All of these duties are done by Door County deputies assigned to the jail. The jail employees in the ETF case failed to prevent evidence of frequent exposure to a high degree of danger or peril. You've been presented with plenty of evidence of the frequent exposure to danger and peril that the Door County deputies assigned to the jail face. The sheriff has presented you with evidence that those jail deputies actually have more hands-on incidents than the patrol deputies. Let's face it, as the gentleman said, this isn't Mayberry. The image of a small-town jail with the keys on the wall and Sheriff Andy Taylor sitting at his desk reading a newspaper, that's stuff of history. That's not the world we live in now. We live in a very different place. In Door County, the jail population is dangerous. There's more violent offenders, more drug offenders, mentally ill people that need to be controlled. Think about for a minute taking the most dangerous people in the county off the street and concentrating them in a single building. And here we're going to have our sheriff deputies in the jail. 4 of them, as I understand, one of which can't even leave his post ever. And we're going to control 70 to 90 dangerous offenders. That's real dangerous. Frankly, I'd rather be on patrol out on the streets. The deputies in the jail are always in danger. The jail employees in the ETF case failed to show that their jobs required a high degree of physical conditioning. In fact, they conceded it, that it didn't. Well, they lost before they even started the case. I don't even know why they went on, because that's one of the requirements. In Door County, on the other hand, all of the sheriff's deputies are required to have all of the same physical conditioning requirements. There's no difference. Whether you're on patrol or in the jail, you're held to the same high degree of physical conditioning. And given the dangerous conditions that exist in the jail, I think they'd be remiss and they'd be putting themselves in danger if they weren't well conditioned. So the bottom line is the employees, the jail employees in the ETF case did a really poor job of making their case, and comparing them to the Door County Sheriff's deputies in the jail is like comparing apples and oranges. You really can't do it. There's this question, of course, about this 51%. You know, we heard a lot about that. So in order to be in active law enforcement, you have to show that 51% of your time is actually spent in active law enforcement or in order to be protective status. Well, our position is in Door County, all of the deputies are involved in active law enforcement for more than 51% of their time, and this includes the deputies that are assigned to the jail. In fact, if you agree that these folks are deputy sheriffs, you don't really have to get to the decision. If they're temporarily assigned to the jail, but they're deputy sheriffs, they should be automatically entitled to protective status. But if the 51% decision is to be made, it's your decision to make based on your deputies, not the ETF deputies who did a bad job on their case. You have to look at the facts and the circumstances of your people. And in making that decision, who do you listen to? Not me. I've never been in jail. But these guys, they work in it every day. And your experts, your sheriff, your chief deputy, your jail lieutenant, they're up here, and last month they were up here telling you that, in their opinion, they know the standard, and they feel that their jail deputies work in law enforcement more than 51% of your time. Listen to them. They know. It seems obvious to me that deputy sheriffs assigned to the jail participate in active law enforcement on a daily basis on the same basis as the patrol deputies. They just have a smaller territory. They work in a building. But like I said, we took all the dangerous offenders and we put them in that building. So it's a much smaller, more concentrated, but much more dangerous territory. And to me, it's telling that the state has said in statutes that their correction officers are automatically, by statute, entitled to protective status. How can that be? The state has said their people are covered, and I think the facts mandate that our people should be covered too. So changing the classification of the deputies assigned to the jail may appear to save money on paper, but in the long run, it's going to cost you more if you consider the detrimental effects. If the change is made, it will put the department in a bind, as it takes 30 deputies out of the pool to work SWAT team, the CERT team, the snowmobile patrol, the boat patrol, to work at the festivals. We have 30 less sworn deputies to do that. If a change is made, it takes away opportunities for deputies to move from the jail to the road and investigations and back again. It's going to be the end of the Door County model. If the change is made, turnover is going to increase substantially. You've been provided with information from other counties regarding the high turnover rate once the change is made. There's no reason to believe that it's not going to be the same here in Door County. Given the geographical location and a little bit of isolation, it's going to be hard to recruit good people. Kewaunee County had 2 full-time positions open, and they received 50% of the amount of applicants that Door County received for 2 part-time positions. You can expect that to change if you change the status of these deputy sheriffs. Excuse me. Experience levels are going to decrease. Now you have over 10 years of experience in the jail. Kewaunee and Oconto counties have told you that since they made their switch they have a level that's 2.5 years, or I'm sorry, 2.2 years and 1.5 years. It's going to be the same here. Training costs are going to increase. If there's high turnover, it only makes sense that training costs are going to increase. The sheriff told the board that it costs approximately $36,000 to train a deputy. That's a lot of money. And the more you turn that over, the more training costs are going to be incurred. Any cost savings that might be predicted and on paper look good don't really take into consideration these increased training costs. The pool of applicants for deputy jobs will decrease. There have been numerous letters forwarded to you from current deputies that are assigned to the jail saying that they would not have applied if they knew that their protected status was going to be taken away. Some of them have even said that they'll actively look for a new job if the change is made. It would be a shame to lose those good people. I think the morale of the entire sheriff's department will decrease. If the change is made, both Kewaunee and Oconto counties have all said that that happened to them. There's no reason to think that it's not going to happen to you. Maybe the most important point is that the deputies are going to lose significant disability rights. This is going to affect the deputies. It's going to affect their families, their children. If a non-protective employee gets injured on the job, they would be eligible for disability only if they are permanently disabled from doing any type of work. That's non-protective. Where a deputy with protective status would be eligible for all that a non-protective deputy is, plus they would be eligible under section 40.65 for duty-related disability. Protected status deputies are eligible for disability if they cannot perform their job duties, are on light duty, are demoted or can't be promoted, even if they can do another kind of job. If protected status deputies are found to be duty disabled, they would receive 80% of their salary as disability. A deputy on non-protected status who might have been injured in the same way, in the same incident, they're going to receive no disability. Is that fair? If a protected status deputy is killed on duty, his or her spouse and children are eligible for survivors' benefits. A non-protective status deputy's family would not be eligible for any of those benefits. The only thing that they would receive is basic retirement benefits, the same as any general employee of the county. The county administrator says that the same opportunities would remain for the employees if protected status is taken away from the deputies. But I think everything I've said shows that that's not true. Even if it was fair or right, would it be fair or right for the sheriff to assign two people, one protective, one non-protective, to the same task where they would be subject to the same injuries, and what different results they would have if in the same incident they were injured the same? Non-protective would get maybe nothing, protective would get substantial benefits. Would a jail deputy want to put her safety and the safety of her family at risk if the differences were so big? I don't think so. So in summary, remember that no one and no agency is forcing you to make any change. The decision is clearly yours. And the state is not going to come in and say you should have done that. If you decide to maintain their protective status, that you shouldn't have done that, no one's going to question your decision. There's not been any challenge to this decision since 1975 to keep these guys in protective status. Even after Act 10 was passed, I don't know, 8 years ago, no challenge to protective status here. No one has challenged Winnebago County. And that Winnebago case that we put in those materials shows that it's perfectly okay if your deputy sheriff's assigned to the jail fit the qualifications to keep them in protected status. Now, it's hard to say, but it's easy to see this as a blatant move, an attempt to break up the Door County Deputy Sheriff's Association. by removing 30 of its members. This decision shouldn't be about union busting. It shouldn't only be about money. It should be about what's best for your deputy sheriffs. It's about preserving that successful Door County model. Think about Act 10 for a minute. And this came to me last night, and maybe it's obvious, I don't know, but, you know, Governor Walker at the time certainly had the votes to wipe out all public unions. But why the carve-out for public safety employees? Why would you do that if you're a Republican governor? Well, I think the answer is because that's the system that ensures that we're going to have the best qualified candidates to come forward and be our public safety employees. And negotiation and the opportunity to bargain is a system that brings in the best people because they have dangerous jobs, dangerous work. And in order to get the disability, the survivor's benefits, they need that protective status. And that's what Act 10 is. It's counterintuitive, but they carved out public safety employees. And your deputy sheriffs on patrol are public safety employees. And your
Excuse me,
deputies. I'm almost done.
Please, please finish your summary.
One more minute. Now, where was I? And your deputy sheriffs in the jail are also public safety employees entitled to protective status. The county administrator is using saving money as an argument to do this. And sure, on paper, you might save a little bit in the short run, but in the long run, increased training, less experience, it's going to cost you money. The bottom line is the Door County has a top-notch sheriff's department that functions exceptionally well. You can all be very proud of that. The Door County model is working. So why change it? The citizens are protected. Don't change something that works. Vote to keep the Door County deputies assigned to the jail in protective status. Thank you for your patience.
Thank you.
Good morning.
Good morning.
Former Sheriff Terry Vogel, just speaking on behalf of this issue here. And I need to get this out of the way. My 12 years as sheriff, I never did formally thank this board for their support for law enforcement, all they've done. Nobody's job in the county is more important than yours, and probably not more difficult either. You guys have tough decisions to make, and we respect that. So thank you. I'm just here to speak a little bit on some of the historical value of this issue a little bit. I started in '76, and I started as a jailer. One of my mentors was Biz Verley, sitting on the county board right now, and I think we've seen a lot of changes throughout the decades together. In fact, when I started in '76, the jailers were not even paid equal to the road deputies. But I think it was in the late '70s or early '80s we took a vote and everybody realized their jobs are very similar, and the pay rate was equal, benefits were equal, and everything was equal. The deputy sheriff was the deputy sheriff. We continued through numerous renovations, 3 or 4, I believe, until the Justice Center was built. And that was probably the biggest change the sheriff's office has ever seen. The jail was by far very important in that decision. I know we had the courts and we had other agencies go up there, but I know when we were going through the process, a very emotional process, some of the studies showed us that we needed to hire as much as up to 34, 32 deputies to run the Justice Center, the jail and the Justice Center. We did our study. We looked at what our personnel could do for us, and I remember deciding we could do it with 18. Part of the reason we could do that with 18 is because we had sworn officers in there. I didn't need to call road guys in to investigate crimes in the jail. I didn't, fights, the great part of this county, the beauty and the natural surroundings, is also the devil in this county. I don't have municipalities nearby that can help out. we are on our own up here to some extent. And that also goes through the hiring process. We get people from out of the county that often have come here and left. And those that stayed, they saw the benefits that this county has, the beauty in this county, the personnel in this county. Changing that status right now, I think would take the heart out of the sheriff's office. These people, when they applied, and I remember Casey Yankee coming in, his first interview, and some of the other officers like that, and I don't remember Casey specifically, but some of the officers I'd asked, well, why did you apply for Door County? And some of them said, because you're sworn officers. Other counties don't have it. So we were really getting the cream of the crop, and I think that really shows in the personnel we've got here, that we could pick and choose those that that we wanted in Door County. I guess call them Door County people, but this is a great agency, and I would just hate to see things change at this point on that. I think in the long run, you're going to hurt the county more than you're going to help it. I've seen these people grow. I've seen these people develop into great officers. I saw some of the emotion up here that these guys that have never shown before that this means a lot to them. And to change that right now, I think you're taking a step back as a county. I don't think you can afford to. Like I said earlier, we don't have agencies rushing from other areas here to help us out. We are who we are. And I just wanted to lay that on you. I'm so retired now, I didn't even bring notes here, and I'm sure I got other things to say here. But I did talk to some of you folks on this issue, and I just think this is an important enough issue for me to come out of retirement after 3.5 years. Thank you.
Thank you. Good morning.
Good morning, everyone. For those of you that don't know me, I'm Tammy Sternerd. I just want to start off by thanking you for the opportunity. And I realize over the last month or so, you guys have been bombarded with different information surrounding this subject. But I've been the jail administrator since 2007, and prior to that, I was a floor deputy and a sergeant that was assigned to the jail. So I have a clear understanding of what it takes to get the job done at each of those levels. This is not the first time that this subject has come up in my 25 years. I was part of the transition team in 2003 for the Justice Center, and obviously staffing was a main issue that we looked at due to the increase in size. We actually conducted a formal staffing study with consultants from NIC to determine what best fit our organizational needs. We had a lot of conversations and research was conducted, and the determination at that point was made that based on our job responsibilities and how the sheriff wanted to utilize his staff, that we were best served by utilizing deputy sheriffs and not correctional officers. Obviously, when we opened our facility, we had to add staff, so NIC recommended that at that time, if you were going to make such a change, you would have done it then when you were bringing in a large amount of people. And then in 2011, I attended an executive leadership course, and I was assigned a research paper. And at the time, Sheriff Vogel gave me the subject of civilian corrections. So I spent nearly a year researching, collecting data, talking to other jails. And this was shortly after Act 10 had went into effect. So admittedly, the change and potential could save money at that time, but it really was in theory because it was so new and nobody really knew exactly how it was going to shake out. I think if we fast forwarded to today, I'd guarantee you that the results of that study would be different. I've attended the Jail Administrator Conference for numerous years, over a decade, and to the best of my memory, we've never had a breakout session on hiring. The agenda just came out last week, and this year we are. And that begs the question, why? And I truly believe my contacts with all the other jail administrators, the reason for that is counties are having difficulty attracting and retaining good people. This job is becoming a hard-to-fill position. Whether people want to acknowledge it or not, the data doesn't lie. Since 2005, we've hired 26 full-time deputies, and we've retained 24 of them. That gives us a 93% retention rate, almost unheard of. One of them left for another law enforcement job, and the other just simply didn't make it through their probation. So that number is extremely important. Much of our success in operating a code-compliant jail has to do with how we choose to staff our facility and how we choose to treat our people. Our current average years of experience is 12. Without that kind of experience, the sheriff will not be able to staff the jail with our current staffing levels. I would anticipate if the change is made, like other facilities, I would anticipate if the change is made, like other facilities, we will have some that choose to leave, bringing that number closer to other jails, which averages about 3 to 5 years of experience. You might ask, why does this matter? As a jail administrator with over a decade of experience, I stand in front of you and tell you, based on my experience in the field, it does matter, and it will affect the ability to run a safe, efficient, and effective jail as we move forward. It's also the main reason I have not went to the sheriff over the last decade and asked for additional staffing, because we can do it with what we have because of the quality of individuals that we attract and hire. Facilities with less average years of experience do require more supervisory staff in order to ensure things are being done correctly. Obviously, with that comes additional cost. The highest number of lawsuits filed by inmates are related to alleged civil rights violations. So without experience in some of those situations, it does matter. You need to have more supervisors with less experience on the floor. So how the board is to come to this decision, I believe it's very clear on the ETF's decision, the case law presented, and the statutes governing the issue, which have all been shared previously with you. One is 51% of their time active law enforcement. 2, frequent exposure to high degree of danger or peril. Neither side is disputing that. 3, high degree of physical conditioning. Neither side is disputing that as well. Nowhere was I able to find the board is to consider cost as part of any equation in making this determination. I would agree it's important and something for discussion, but not as part of what is in front of you to consider today. If you are applying the ETF's criteria for determining protective status, cost is not in any equation. The deputies assigned to the jail prevent, enforce, and protect public every day, the same as patrol deputies. Crimes do occur in our facility, and just because someone's incarcerated, they don't lose their right to protection. Just the other day when some of you were at our tour, my staff that day, they were dealing with investigating a theft, a felony intimidation to a witness, and a bail jumping with 3 people. So they are active law enforcement. Just their pure presence avoids a lot of issues. We rent beds to facilities all over. And people come in, and it's kind of weird to hear them say that, but they ask if they could stay. You know, you don't see that if you're talking to Brown County Jail or another place like that where there's a huge amount of population and not enough staff. But since money has been brought up, I guess there are some things as the jail administrator I feel is important that I do get a chance to speak about, and that's training. The level of training that we get is appropriate, and it's some of the best training throughout the state, but it does cost money to train someone. So when you have turnover, it does cost the county. Then also, as part of the administrative team in budgeting, for the last 10 years, we've always returned money. So the reason for that is because the jail generates a lot of the revenue, about $300,000 annually. I mean, today's inmate population before I left is 107. 34 of those are rented beds. And I've been able to do that with the current staff that I have without coming to you and asking for more staff. So we continue to generate more revenue. And now moving into 2019, that revenue that's generated is going to be utilized to benefit other areas in the county. They're looking at treatment courts, such things of that nature. You know, in all fairness, we did present in April of 2016 a change to our hiring process. And at the time, the reason we were doing that is to try to start reducing overtime. And in all fairness, we said it would take a full 2 years before this, once we implemented it, before we'd start seeing the savings. And we haven't even had a full year of that. So I don't think it's fair or realistic to just look at our 2017 number and say that we were over budget, because if you look at our department as a whole, we weren't over budget. Our overtime had went up in the sheriff's, on the jail side, but down on patrol. And the reason for that is because we're moving people out to patrol quicker. So I think it needs to be looked at big picture, not individualized. And, that being said, there's not a clear definition of active law enforcement for the 51% rule. So I'd ask all of you, who would be best suited to advise you of this? And my answer is simple. It would be the sheriff. The citizens of the county elect the sheriff and entrust him or her with the responsibility of public safety. The sheriff and his administrative staff are the subject matter experts. And we all have stood before you today and previous times and said we need to maintain our current status, and our staff and our facility needs to be staffed with sheriff's deputies, not correctional officers. As I was preparing for today's meeting, I came across a PowerPoint that referenced this, and I quote, "Counties have a statutory duty through their designated ETF agent to correctly classify an employee's protective or general status in WRS. In order to make a determination as to the duties and responsibilities of personnel, or whether those same duties and responsibilities make one eligible for protective status, counties are encouraged to engage in due diligence. The first step is to engage the sheriff in a discussion to better understand the department's organization and general job duties. To the best of my knowledge, no one came to the sheriff, the chief deputy, or myself and sat down to discuss this issue to find out what exactly the duties are, how we utilize our staff, and the vision for the future of the use of these deputies. That is troubling to me. We should not be relying on an outside individual to evaluate this important subject, from reviewing job descriptions and without any actual face-to-face interaction with the administrative staff of the Sheriff's Department to verify and gather information. It's not against the law to keep these people under protective status. If the job descriptions need to be changed, then we work with human resources to do so. I don't see anything hard about that or complicated at all. While the ultimate decision on protective classification lies with the county board, the implications of the decision resonates with the sheriff, the county employees, and the taxpayers. Under Chapter 5927, Sheriff's Duties, the sheriff of a county shall do all of the following. His or her number one responsibility is take charge and custody of the jail maintained by the county and the persons in the jail, and keep those persons in the jail either personally or by a deputy or by a jailer. Our sheriff has stood in front of you and said he needs to maintain his jail with deputy sheriffs. There's two other issues that I have. I feel a little uncomfortable arguing about my own job, but I'm going to do it anyway. The resolution includes the jail lieutenant position. I'm not going to be in that position forever, so I'm really not arguing for myself. I'm actually arguing for the future of our department. Our command structure, there are 4 individuals that are an administrative team, and the jail lieutenant is one of those. The sheriff decides how he wants to utilize those 4 administrators. This position would be the only administrative position that you would not cover under protective. This position is mandated to carry a firearm and be state law enforcement certified. In the absence of the sheriff or the chief deputy, either myself or Lieutenant Lauder on the patrol side needs to deal with anything that the sheriff would otherwise deal with. So I would ask you at a bare minimum to consider, and I noticed the job descriptions and stuff for that was not included, so I did want to make mention to that. That is a job that, again, is administrative, but we are responding to situations that are law enforcement related. So I'm not going to go into too much about that. The other one, though, is the deputies that are assigned to court security. I feel that they got thrown into this basically because I supervise them and my title has jail in front of it. So I just want to make it clear that they are not part of the jail staffing. They are required to be law enforcement certified and carry a firearm. Again, I said they are under my supervision, but it's because logistically it makes sense because I'm generally the one that's in the building the most. That's the only reason. And Deputy Schwartz read the reasons why the judges want that, so I'm not going to go over that again. But I think it's important that you do understand that every day individuals enter the Justice Center for cases that are highly charged and very emotional for those involved, such as child placement, divorce, restraining orders, sentencing, etc. These have high potential to escalate quickly. I've seen firsthand the effect of having their presence in the courtroom and how having them has allowed us to maintain order and protect those working in the courts and visitors to the Justice Center. As a supervisor, I do track their annual workload because we do need to report that to the Facilities and Security Committee. So this job was pretty easy to say what percentage of their work was active law enforcement. After we analyzed the 5 years, 59% of their time is spent on prevention, detection, response to calls for assistance, making arrests, serving warrants, or paper service. 24% of their time is on arranging transports from other law enforcement agencies to prison, medical appointments, or hospital duty. 17% of their time is spent on other law enforcement activities. The uniqueness of our department is we don't have an overabundance of staff in any one area. So these individuals, because they are deputies, we're allowed to use them in our investigative division, festivals and things that were said earlier. So they also take care of all my Huber checks out on the street. They man the victim impact panel, and they are the electronic monitoring compliance officers. So they go out and check people that are on electronic monitoring. And checkpoint, obviously somebody has to be there 24 or all day. So they average about 17,000 or so people screened. And honestly, this position has the most interaction with any amount of people from the public. And they average about 367 weapons taken through that checkpoint, removed, and about 53 arrests annually. So based on the evaluation of the ETF, they clearly spend more than 51% of their time participating in active law enforcement. So I would ask you consider at least removing them from the resolution. In closing, when I woke up this morning, I go to my closet, I get my uniform, I pin my badge onto my uniform, and I do say a little prayer for myself for a safe return and for those that work with me every day. For me, I've always known walking out the door when I tell my family, hey, I love you, see you guys later. I've always known that that may not be true. But what motivates me to do it is I know that if something happens to me, that my family is going to be taken care of. That's why I do what I do. I like to do what I can for the community, but assuring me that my family will be taken care of means a lot to me. And all I ask of you is to please consider to allow these people to enjoy that same thing as they walk out the door every morning. Thank you.
Thank you.
Good morning.
Morning.
I'm Pat McCarty. I'm the Chief Deputy for the Sheriff's Office. If it's not broke, why fix it? As I speak with other Chief Deputies from around the state, they all have the same issues: recruitment, retention, and the difficulty in filling vacancies. 25 years ago, many agencies, including Door County, took the opportunity to use federal grants to hire more law enforcement personnel. And now, as these officers are retiring, the current pool of potential applicants is not sufficient to fill these vacancies. Vacancies require mandatory overtime for shift coverage and stress staffs with long overtime shifts. Door County does not currently have that problem. In the last 4 years, we have not seen much attrition other than retirement. We have not lost an officer to another law enforcement agency since 2014. This was a regular occurrence in the first half of my career, where officers would come to Door County, gain some experience, and then move on. The Door County Sheriff's Office was a de facto training ground for the Brown County Sheriff's Office in the Fox Valley metro area. Our officers do not view the Door County Sheriff's Office as a stepping stone in career progression for another agency. They view this position as a destination where they want to spend their careers. I do not have to look far to see officers struggle or see departments struggling with turnover. The Sturgeon Bay Police Department has struggled with recruiting of quality applicants. They have experienced a high turnover rate, losing officers to other law enforcement agencies and to other careers on a regular basis, and they're in a constant cycle of hiring, training, only, and vacancy. The Kewaunee Sheriff's Office has experienced a high turnover rate in the aftermath of the change you are now considering. We have benefited from Kewaunee's move, hiring one of their deputies into our communications division and one of their former deputies into our jail division. Kewaunee Sheriff Matt Joski has told me that it had not saved any money in making this move. It has negatively impacted the morale of their department, and they are not attracting quality applicants to fill their vacancies. Making this change will have a direct impact on our ability to protect the citizens of Door County. Our current model of hiring employees part-time and allowing them to post into full-time vacancies will not work. We will not be able to attract candidates willing to work extended periods without benefits, without the attraction of the protected status. It is protected status that separates us from other prospective employers. Vacancies in our patrol division are currently filled from deputies in the jail division. The experience our deputies gain in a jail has a direct benefit on their ability to succeed on patrol. It is the jail that they learn the value of communication skills, de-escalation techniques, and problem solving. There is a fiscal impact to the change you are about to consider. A constant turnover in our jail staff will diminish our ability to house inmates from other agencies. We are currently able to take prisoners from other agencies without increasing staff because we have a seasoned jail staff. Inexperienced staff requires more supervision and can be given less responsibilities. Our training costs will go up significantly with the increase in staff turnover associated with this move. Our shift coverage overtime will increase as deputies leave to take other positions with other agencies. There are ways to reduce costs through the collective bargaining agreement without making this move and its catastrophic results. Thank you for your time.
Thank you.
On the last one. For over 40 years, this county has saw fit to classify our jail deputies as protected. It has been brought to you, before you, to change that. You've been given a ton of information in a short time to digest and come to a decision. You have heard plenty from both sides and are probably ready to have this over with. But this is one of the most important items I've dealt with in the past 4 years. If you vote to go with general status for our jail deputies, it will have a ripple effect in the Sheriff's Department from this day forward. We will no longer be an attractive place to seek a career. No matter how you window dress it, new employees are looking for long-term stability, especially in law enforcement. We will not be able to rely on the charm of Door County to attract people. Up to this point, we have benefited from the protected status. We've been able to draw top employees from other agencies because they don't have it. As you've been told before, prior to Act 10, the status for county jails was approximately 50-50 between general and protected. After Act 10, many counties changed their status. Not because the state told them they had to, not because of the EFT, but a short-sighted attempt to save money and eliminate bargaining units. What other sheriffs have told me is what they ended up with was a constant turnover, increased overtime, and training. I've spoken with Sheriff Lucas in Portage County, and their county board was all set to change back to protected status until they found out the jail employees would still be bargaining, and then they dropped it. Also in the resolution are included the jail administrative position and the court security deputies. This concerns me because they are not even in the ETF ruling. I called the sheriff in Chippewa County where this ruling came from. He told me their jail administrator is still under protected status. And they just started a court security position, and that is under protected status. Our jail lieutenant position is a jail administrator, and as part of our administrative staff. The jail lieutenant position in the ETF ruling is a jail supervisor, a floor supervisor similar to our sergeants. He also told me that their switch was based off of the county board being told they'd save $220,000 a year. He stated their expenses have doubled since then. He's lost 12 long-term employees to other departments as they switched to departments with protective status. They've been in a continuous mode of hiring and training people. When we hire someone, we issue them a deputy card. They are a deputy sheriff of Door County. They sign an oath saying they are a deputy sheriff of Door County. The 2012 ruling by the Wisconsin Employees Relation Commission in the matter of Winnebago County had a finding that their corrections officers were appointed as deputy sheriffs by the county sheriff pursuant to statutes and were under protected status. And Grant has stated that the ruling, the ETF ruling holds precedence over the Winnebago decision. And I'm not going to dispute what Grant says because he's way smarter than me. But I believe he would even agree that the ETF has not challenged any county that has determined that they believe that their jail deputies meet the criteria. Thank you for your time.
Thank you. Anybody else? Good morning.
Good morning. My name is Arlick Porter. I'm the Sturgeon Bay Police Chief. I've been a police officer over there 39 years. I had no intention of speaking this morning, but when I listened to these men and women that I consider our partners, the Sturgeon Bay Police Department, it really became a quick, easy decision for me to make, but I will be brief this morning. This is a difficult decision, but the men and women that you've listened to this morning, it will affect their lives, their future, and the future of Door County. These folks that are deputy sheriffs and in law enforcement are your most valuable resource and asset that we have. And the sheriff and I have access to resources that are millions of dollars, helicopters, airplanes, watercraft. It gets down to people. And these folks, again, I'll repeat it, are your most valuable resource and asset that you have. Please do the right thing, and I urge you to keep them in their status as is, move forward. Door County is a role model in the way you operate the Sheriff's Department and the jail, and these folks are tasked with it. Back them, listen to your subject matter experts. There's a lot of experience in this room, even taking out my 39 years. Thank you. Make the right decision, please.
Thank you. Anybody else? Last opportunity? Okay, public comment will now be closed. We will take a 10-minute recess, and we'll come back and move on our agenda.
I thought I don't take those.
So that doesn't work. Okay, we're now back in session.
He's got to bend down.
Next item under public comment, supervisor's response. Penny? Approval of the minutes of August 28th, regular meeting.
I'll make a motion to approve those minutes as presented, Mr. Chairman.
Second.
Any changes, additions, deletions, comments, grammatical remarks, or otherwise? Not, all in favor?
Aye.
Resolution Non-commercial hangar site lease arrangements, agreements, Resolution 2018-56. Mr. Ninus.
I make a motion to approve Resolution 2018-56.
I'll second that.
This is, if I may, Chairman, this is a standard lease agreement approved by the committee and it's before the board due to a 10-year lease term.
Any questions? That will go to the voter board.
So, I did it. Do it again.
That has passed the vote 21 yes. Thank you. Resolution 2018-57, petition the Secretary of Transportation for airport improvement aid by Door County Cherryland Airport, Door County, Wisconsin. Mr. Ninus.
Mr. Chairman, I make a motion to approve 20-1857.
Second it.
This is by mutual agreement going to be spoken of with our county administrator.
Could have given me a heads up, no, just kidding. So again, in this, for the item that you're considering, we have to go through a federal process of going through a planning process and then doing a public hearing and then actually establishing, I guess, the petition of what funding we're looking for at the airport. So again, we went through that process. We carried out the procedures at the Highway Committee as required, and it now does come to this body in terms of approval. And really what you're approving is the ability for us to, in essence, submit our, I guess, request for aid improvements to see if we can leverage funding for the projects that we identified. That's the short version. So it's really a procedure that we have to follow for us to qualify for federal grants for the airport. Some of the projects, if you're wondering, mainly are focusing on airport improvements in terms of the runway, and also some of the areas around, I forgot what they're called, as far as the taxiing areas, in terms of improvements in that area as well. So those are the primary, I mean, those would be the big ticket items that are within that.
Questions? Linda.
So this isn't an automatic, you have to apply for the funds?
Correct.
And if we were awarded funds, are there any stipulations or conditions that go along with it that we will give you money if you add this or improve this? It's strictly for the purposes indicated in the resolution?
Correct. And this one thing to also clarify is that in some of the cases, like for example, we set aside money now for future projects as far as matching for the runway, and we did that when we did the last runway improvement. So usually the runway grants, depending on what they are usually like a 90-10 federal local match. Again, there's been a lot of stuff going on at the federal level in terms of, I guess, what they consider enabled projects. So there's been discussion that some of those could be 100%, but I guess I'm definitely not promising that. There might be some additional local match, but that's something that we have in our CIP where we try to set money aside and get those dollars.
Thank you.
Any other questions? If not, we'll go to the voter board. That's passed on the vote of 21 yes, 0 no. Thank you. Resolution 2018-58, approval of the EPCRA countywide strategic plan. Joel?
Yeah, I'd like to make a motion to approve Resolution 2018-58.
I'll second that.
What this is a boilerplate application that gets done every year. It keeps the county in check with our application process for money for emergency management and strategic planning, hazard mitigations type stuff. If Mr. Kane has anything further to add, that would be outstanding, but it's a thing that we need to keep up on every year to get some money for it.
Questions? David?
Not really a question, but regarding the map, there's more than one map involved with this. The map showing the roads in Door County. Apparently, it's an old map that's used. It doesn't include the route for Highway 57, as it currently has been for 10 years. So I'd like to see those updated.
We can make that so.
Anybody else? Then we'll go to the voter board.
Oh, sorry, thought I did hit it.
That has passed on a vote of 21 yes, 0 no. Resolution 2018-59, committee appointments. Ken?
Sure. So just some quick background on this. Obviously, working with Dan and obviously the plan that we just did, one of the things that we have is the local emergency planning committee. And if you recall, we usually have those appointments made. When Dan came on board, he did the plan and he actually went through all of our, I guess, committee members. And they actually are actively meeting, which is good news. But we also just wanted to go through now and also update our committee members. So if you look at page 48 of your packet, it shows the listing of all the members with their terms. I wanted to include them all, that way it's just clear in terms of what we're adopting. And again, you'll see the items that are in blue along with the biography of Bob Mayer, who's going to be taking one of the positions from the Red Cross. And we're just looking for your support just in terms of the committee appointments.
Helen?
How come all the terms end in 2019? Usually don't boards have rotating terms or revolving so that you don't have everybody at the same time?
Well, I guess we could do that, but in a lot of these cases, if you look at a lot of those members, they're actually tied to specific positions or from that standpoint. So why they all end, a lot of those would naturally carry over. So, I mean, we could look at that in the future, but that's the way it was originally established. So, but we could look at that in the future if you'd like.
Mr. Chairman, I'll make a motion to approve Resolution 2018-59.
Thank you.
Second.
Any other discussion or questions?
Is Mr. Mayor here that he would want to be introduced?
I don't believe so.
Okay.
Anybody else? If not, all in favor?
Aye.
Opposed? Resolution 2018-60, authorize application for an acceptance of financial assistance for Robert LaSalle County Park prairie planting. Mr. Ostead.
I'd like to make a motion to pass Resolution 2018-60.
Second.
Okay, what this is at LaSalle Park, in the southern part of the county, they want to plant some prairie grass along the road or the entrance north of it. And this is apply for a grant of $3,700, which half of it has to be met by the county. And the money for the half that has to be met by the county is going to be given to the county by the Friends of the Door County Park System. So there's really no levied taxpayer dollars applied to it.
Any questions on the prairie planting at LaSalle Park? If not, we'll go to the voter vote. Linda? That has passed on a vote of 21 yes, 0 no. Resolution 2018-61, grant of easements to Wisconsin Power, Cana Island. Mr. Ostead.
Yes, I'd like to make a motion to approve Resolution 2018-61.
Second.
Okay, what this is on Cana Island. They want to put an underground electrical system from the beginning of the island to basically the lighthouse, even though it's not right to the lighthouse, it's about 100 feet off the lighthouse. Eventually, they want to bore underground under the causeway, but those easements are up to the DNR and some other people, not us. We're just dealing with the island itself.
Questions? All in favor?
Aye.
Opposed? Resolution 2018-62, appointment of the Door County Finance Director.
Excellent. So would Steve would like to maybe come up, but I'd like to, again, I think I announced it before, but we went through an extensive process in terms of our review, and very pleased to announce that Steve was appointed our new finance director, and I can see that he's going to try to take on some trends from Mark. It's a good one that it's not a Bears Hawaiian shirt, so that's a good start. But I would like to at least introduce Steve and let him make a statement. So.
Good morning.
Morning. So now, with this shirt, now I'm ready for the job. This is a great honor for me and my family. I would like to thank the county administrator and the interviewing committee for the confidence that they have in me to become the next finance director. I'm grateful for all the knowledge the current finance director has passed on to me. But don't worry, despite his best efforts, I'm still not a Bears fan. I look forward to the new challenges and the opportunities this position has to offer. And I look forward to working with all of you. Thank you.
Thank you.
Thank you.
Mr. Chairman, I'll make a motion to
Are you going to stay around longer than the last
Resolution
one? Are you gonna stay around longer than the
2018-62.
last one?
Second.
Second, Laura. All in favor?
Aye.
Opposed? Resolution 2018-63, resolution in support of increased county child support funding. Somebody like to make a motion?
I'll make a motion to approve Resolution 2018-63.
Second.
Ken?
Actually, if you don't mind, I'll defer the next two. That's to Grant because he has the background. I mean, I can do it, but I think Grant can explain it a little more concise.
Yeah, an attorney doing something concisely, but
A double negative.
yes, it is. Paired to its essence, the funding levels for county child support efforts, and the child support efforts include the establishment of paternity and also the payment of support obligations, including requirements to obtain or maintain health insurance, have remained static for roughly 11 years. And the purpose of this resolution is to encourage both the federal government and the state government to increase the funding that is funneled through the state government to counties to provide the child support agencies funding to do what they do, which again is to establish paternity, child support, and other obligations. I don't know, above and beyond that, it's about as simple as I can make it. I can answer some questions if anybody has any. My understanding, I was not there unfortunately, that this was a focus of discussion at the annual conference in La Crosse, and this is something that sounds like the WCA will be carrying forward. So,
that's correct.
Any question? Not on a voice vote. All in favor?
Aye.
Opposed? Carried. Resolution 2018-64, in support of increase in the compensation for the defense counsel appointed by the Wisconsin Public Defender's Office.
I'll make a motion to approve that, Mr. Chairman.
Thank you. Is there a second?
Second.
again, very briefly, what I want to mention here is it's almost counterintuitive, but the funding for the State Public Defender's Office, and which includes not only staff attorneys, but attorneys that they appoint to handle cases, does directly impact the counties, because if somebody is either found ineligible for public defender representation, or perhaps more to the point, there are not attorneys willing to take these cases at the rate the state public defender pays, then the burden falls to the county to appoint counsel and pay for counsel. That isn't a significant problem yet, but it could be. And one thing to remember with the State Public Defender's Office is that it not only provides representations in criminal cases, it also provides defense, or perhaps a better word would be adversary counsel in civil cases. For instance, to parents whose children are subject of CHIPS proceedings, child in need of protection or services. And if we don't have private attorneys willing to take it at the state public defender rate, the burden falls to the county and it negatively impacts the county's bottom line. What this resolution does is to increase the funding and level out the playing field. And the most egregious thing is the level that the county is required to pay for outside counsel, which was recently raised from $70 to $100 per hour. The state public defender rate is $40 per hour. If I'm sitting in a private law firm and I get a call from the public defender to take a case at $40 an hour, knowing that if I say no, the next call might be from the judicial assistant or the clerk of circuit court, for the same case at $100 an hour, which one do you think I'm going to accept? So it's a common sense measure to level the playing field and make sure that the State Public Defender's Office is adequately funded so it can perform its responsibilities and so that those responsibilities don't fall to the county.
Okay, thank you. Questions? If not, all in favor?
Aye.
Opposed? Carried. Resolution 2018-65, part-time pay rates, replacing Resolution 2017-67.
I'll make a motion to approve Resolution 2018-65.
I'll second it.
Ken?
Sure, this one's actually pretty straightforward. If you look at page 61 of your packet, there's actually the, I guess, far right column. It actually shows, what we do each year is we show all the part-time pay rates. That way we keep a track historically what's going on. There's only 5 areas that are identified in terms of changes. We have the standby bridge tender, it's going from $17.50 to $17.75. This added a class 5, which is for the security in the parks, and that's a rate of $14.50. Again, we actually have that, so there's not a fiscal impact related to that, but we wanted to identify that. And then the other changes are within the museum. We have the museum, I guess, director and assistant curator, and we're going from $18.85 to $13.25 and from $12.10 to $12.50.
Questions? Now we'll go to the voter board. Pass on voted 21 yes, 0 no. 2018-66, new position request for 2019, increase of hours, reclassifications, and new positions. Somebody like to make a motion, please?
I'll make a motion to approve Resolution 2018-66.
Thank you.
I'll second.
Thank you. Ken?
Okay, I'm just going to take a minute just to walk through it so you guys have a chance to understand what's being, I guess, approved. So really, I'm going to cover everything on page 63, I think is the best summary. And I'm just going to go through quickly each department, and if you have a question, I'm more than willing to go into more detail. First one is the district attorney, the request to go from a .8 to a full-time FTE admin and admin assistant 2. Again, what we did in the previous year, we actually budgeted for a part-time position, but we held off on it just to determine the level of work. With the timing, they had, I guess, turnover in the department this year, and I appreciate it. They did analysis on what their workloads are, and they actually came up with an alternative of, instead of hiring an additional staff, we're just modifying or increasing the hours. By doing that, the impact is just only $310 in terms of the levy, but just by making that change, we significantly increased the amount of, I guess, talent within the office in terms of our qualifications, because we actually went from admin 1 to admin 2 on a previous position. So it's a very positive move with a very negative, minimal impact. Under human services, we do have a process for individuals to request a reclassification based off their job duties. We have those listed there just for reference, but the consultant that does that for us recommended no change. If you go to the human services for the ADRC, we have a request from a .5 FTE to the full-time for the cook and an increase in LTE hours at the ADRC. You can see the fiscal impact for both of those, $22,337 and $12,585. Both of those were recommended by administration and also the admin committee for approval. Again, if you've been at the best thing about our building is not only it's beautiful, but it's being used. And we have, our numbers have not gone down whatsoever in terms of meals, and in fact, they are still trending to be higher, which is excellent. So with that, we need to be able to function and operate the kitchen. So that's where the recommendation is to support that. The other one was more, the transportation one is, again, this was more just of a way for us to track it, so that way it's transparent of how we're handling. But if you do recall, at the last meeting, we talked about the transportation program and how we're looking to, I guess, look at its overall operations and how we're going to move forward with it. In our discussions, we talked about allocating some funds this year and then funds next year towards that effort. So again, that's just more of an FYI. It actually is already built into our budget, but I want you to just track it in terms of how we're tracking positions. Then if we jump down, we go to human services, and I just categorize it overall within the human services division. The first one is the request of the full-time psychiatrist. Joe is here. He can provide tons more detail, but I'll give you the quick version. As you recall, we transitioned, obviously, from a full-time, then we reduced some of the hours. Then when we reduced some of those hours, we did it again. Then individual wanted to leave or relocate, so we did telehealth. That worked for a little while, but we had some issues with that. And then we built a partnership with Kiwani, which is what we've been doing for approximately a year. That has worked. There are some issues that I can go into, but there are some issues just in terms of the performance and how that's working out. So what we did is we sat down and looked at our overall services, and we did an analysis based off what we need to operate if we would continue, I guess, either with a part-time position or the partnership with Kiwani. We'd have to bring on staff that could help, I guess, work with the doctor and also be able to disperse medicines. If we go to a full-time psychiatrist, you can actually see the impact is actually a negative. So in other words, our projected expenses, if we don't make the change, is $317,200. If we do switch to a full-time psychiatrist, we actually save $56,000. I know it sounds crazy, but Joe assured me that those numbers are correct, and we did check. So, but again, it's just a way of making us operate or how our operations work in dealing with patients. So again, that recommendation was to approve. The next two, I can get into a lot more detail, but I can just say that there was requests for 2 more positions, one in the children's long-term care, and one is the CCS, or the Comprehensive Community Case Manager. In both of those cases, you can see the fiscal impact of approximately $30,000 and then $41,000. The best thing I can say right now is I think that there's value to considering these, and it might be another request that we see next year. I think it's just a matter now of getting, I guess, our feet underneath us better to understand exactly how we think we're operating, exactly how we're actually collecting revenues within human services. Because within that area, it's not a matter of if, it's when we're going to get audited. And I think the biggest thing that we can do is make sure that we're operating, and it's not a negative comment at all in terms of how they're operating, but I think we need to be in a better position of looking at our percentage of returns, how we're billing our rates, our caseloads, and all that type of stuff. So I think it's just a matter of managing our growth and the speed of our growth and taking a year to grow into that. So from that recommendation, we have that as a no. Going to the library, we have a archives researcher. That is an impact of $20,197, and that was recommended by admin as approval. Again, when we get to the back side of the page, you'll see that we're actually taking money out of our museum fund to actually pay for that researcher. The reason why we're doing that is we're actually looking at considering moving the archives from the museum to the library, and we're working on how that process would move forward and how we could develop that program. The next one, under the sheriff, this is more of a tracking item. Again, it's listed under the sheriff, but it actually reports to human services. Is under the grant that Tammy was successful in obtaining. We got approximately $80,000 this year and $80,000 next year to what's considered a case manager. And part of the program that she has established as far as treatments. Again, with the way the grant is stipulated, we can't use all of the $80,000 just towards salary, so we need to find some additional, I guess, dollars to offset that. And again, I think Tammy explained to that we're actually going to use increased revenues from the beds to actually cover that expense, so there's no impact. But I just wanted to have it tracked so that way we know we have an LTE position that's on the books for a year, but it's not going to be in the books long-term unless we find a solution for that. So with that, if you turn the page, you'll actually see this a summary chart. And what's interesting is although we're adding some positions, the psychiatrist makes a big shift. So the total fiscal impact on the tax levies projected to be a negative $19,550. So that's the quick version. I know there was one question, just to maybe throw it out there for the psychiatrist, is that in essence all in is the covered benefits and all that related to it? Yes, that includes the wage, their benefits, vacation, and all that. That's all projected when finance reviews those figures, and that's included.
Questions? Linda?
I have a couple questions. I know that the departments and the committees have reviewed these recommendations, and the resolution states that they recommend that the full board pass them. But the blanket, I always have concern with blanket resolutions instead of a case-by-case or position-by-position. So although I may agree with most of these, perhaps I don't agree with one or two. And so if I vote no, maybe that's something to think about for the future instead of lumping it into one resolution, a case-by-case or position-by-position, especially since some of these numbers are quite substantial. So, and then I did email with Mr. Pavic on the psychiatrist. My concern there is I'd like to know the base salary for one thing, because I did look at average pay rates for the state for a psychiatrist, which range anywhere between 185 and 260. So I'd like to know the base salary. I would like to know, under the current contracted services, is this psychiatrist on call 24/7, weekends, evenings? And if we hire a full-time person, is that person going to be on call 24/7? What do we do when that person is on vacation or whatever? Will we end up contracting with someone else and negating our cost savings?
We see Joe working his way to the microphone.
In answer to the first question, I'm not exactly sure what the base salary was. I know I got those figures in working with Kelly. I want to say it was in the neighborhood of the $185,000 is where we used as a base salary. In terms of on-call, we have a crisis team that's on-call 24/7. We have, in the 20 years I've been here, never had the psychiatrist. They've always been on-call, but they're really a backup, like kind of the third down the line. We almost never have called them in that time frame. So we don't contract for that service. We have mental health professionals that provide the in-field assessments of individuals, and typically will follow up with the psychiatrist the following day or on Monday if it's over a weekend.
Vacation?
Excuse me?
How do we handle the vacation part of that upper question?
Again, we have mental health team on. When we had a full-time psychiatrist, when she was on vacation, we covered whatever we needed to in the meantime. The doctor they don't do a lot of emergency response kind of things. They're primarily doing medication monitoring and medication prescription. So that is not handled on an emergency basis.
More of a scheduled.
Yep, correct.
Vinny?
I have a question about the caseloads in the section that refers to the state mandate, and there are 22 kids on the list, and those two, and also the community service case managers. I just wanted to get a sense of what the caseload is now and how this decision of no may impact your ability to provide those services. And if I'm understanding that right, that there are 22 kids on the list, can you explain a little bit more what that means?
Yes, so in children's long-term support, which is the program with the wait list, the state has
asked all counties to eliminate their wait list as of this year. We made a commitment to the state to move 14 kids off of our wait list in 2018 based on what we believed we could staff and handle by adding more kids to our ongoing caseloads. At this point, we have let the state know that we do not have room to move more kids off of that waiting list without additional staff and have requested additional funding. That additional funding has not been approved, or has not come through from the state. We're not the only county who has kind of pushed back on this and said, look, we don't have the capacity to move all of these kids into the program. So some of these kids have been on waiting lists for some time and will remain on those waiting lists at this point without that position. In the CCS program area, our average caseload is about 15 cases. These are complicated mental health cases. We don't currently have a wait list, and technically we can't have a wait list. We probably have 3 or 4 folks kind of slowly transitioning in at all times. But we are at capacity in both of those programs in terms of our case managers' ability to take on more cases.
Linda?
One more question, probably for Mr. Kresbeck. The psychiatrists, would they be an at-will employee then, or would you be required to enter into a long-term agreement with them that you're going to be on board for 3 years or not? So,
I'm not sure that we have clarified that, but when we've had a full-time psychiatrist in the past, they have been an employee just like everyone else in the department. They've not been under contract.
subject to review and
Oh, yes,
and all the other.
Definitely, yes.
Anybody else? Now we'll go to the voter board. Passed on a vote of 21 yes, 0 no. Resolution 2018-67, transfer of non-budgeted funds, recruitment of psychiatrists. I have a motion.
I'll approve resolution number 2018-67.
Second.
Thanks, David.
So I think I can handle this one. If not, Joey can back me up again. But this is a short one. As there is in all of our positions, we're having a difficult time, and psychiatrists are a definite premium. We've had our position posted. It's been on the website, even though we had a partnership with Kewaunee County. We've had it posted on our website for at least a year and a half with no applications. I asked Kelly to do some research in terms of working with some recruiters. She's contacted several, and we think this is a viable option to move forward. I know Joe has one potential person that we might not even need this, but for right now, we're trying to get this set up. And in essence, what we're requesting approval for is, again, to take the $30,000 to work with a professional recruiter that can help us find a psychiatrist. And what the recruiter does is they go obviously through the process of trying to find us qualified candidates, but really what they do is they actually vet out candidates that are seriously interested in pursuing this job. So it's not like we're going to have people that's randomly flying up here, interview and say, well, I had never any intention of actually doing the work. So really what we're asking that recruiter do is to find viable candidates that we seriously want to consider. Hopefully we narrow that down to 1, 2, or 3 at the most, and they actually come up, we do the interviews, and we go through that selection process. The $30,000 covers the expense of both the recruiter and also the recruitment process of individuals that we might consider to fly up, and obviously their boarding and that type of thing. You normally have to do that in considering those types of candidates. The reason why we're asking for it out of contingency is really just we don't know what the timing is of how this might occur. So we can start immediately in terms of the recruitment. It could be 3 months, it could be 4 months, 6 months in terms of when this occurs. So it could span both this year and into next year. So that's why we're just asking to set the funds aside, and we can draw down from this no matter what, I guess, fiscal year it hits.
Questions? Linda?
I'm sorry. Going back to the contract thing, so we currently have contracted services. Does that contract end at the end of this year, or can we extend it month to month so that we're always covered if we don't find this right person?
I guess
right
our
away?
goal would be is to try to work with that, with Kimani and that individual to see if we can maintain that relationship. However, Joe said it, and I'll just say it, is that obviously they know now that we're pursuing someone, but,
Right.
so they might have the right to say no. So we might have to do an alternative where we go back to the telehealth for a little bit. But again, we obviously try to work with Kimani County and see if we can extend that, but again, it's kind of one of those things of, it's really their decision if they want to participate with us.
Vinnie?
Have we gotten any feedback as to why we haven't had an applicant in that time frame, or just, it's hard to answer that maybe, but.
Well, I don't, actually, Joe might provide some insight. I just know right now that it's very competitive to find psychiatrists. It's just one of those fields where right now there's a short supply of them. They're in very high demand. In fact, I know Joe went last year. I always tease him, but he actually went to Kohler and actually went to a conference for psychiatrists to actually, and he set up a booth and all that kind of stuff, and he tried to have some of those interactions.
Yeah.
So I didn't see him on the golf course with any pictures or anything like that, but, you know, he did actually went through that whole process. And so, I mean, if Joey want to provide more insight, but it's just one of those fields where it's very, very difficult to find someone, and it's very competitive in terms of how we can draw them in. I don't know, Joe, if you want to add anything else?
He's not that bad.
Any other questions? Now we'll go to the voter board. Passed on the vote of 21 yes, 0 no. Resolution 2018-69, right of first refusal. Mr. Fisher, I'm sorry. Ken, you gonna do this? No.
Well, you want to get out motion?
Yeah, but who's gonna do it?
Oh, Grant.
Brent, okay. Can we get a motion on 69?
I'll make a motion to approve resolution number 2018-69.
Is there a second?
Second it.
Thank you. Brent?
As part of the acquisition of the property upon which the Justice Center and the highway shop sit, the county acquired a right of first refusal from the owner, Mr. Remy. And that right of first refusal applies to a 40-acre parcel that is depicted, I think, most clearly
Page 74.
on page 74 and on the pages of the packet. And that 40 acres is divided into a number of parcels. The first parcel has, since we've purchased the property, has come up for sale, and there is an accepted offer. And the county has to make a decision in my mind now whether or not we intend to exercise the right of first refusal with respect to that 40 acres of property. If we don't exercise the right on this smaller parcel, then it really doesn't make any sense to do so when the other parcels come up, and vice versa, I guess. Just because we exercise the right on this parcel, if we decide down the road we don't want to exercise the right on the other parcels, it would always be possible to treat this as surplus property and resell it. My recollection's not entirely clear as to why the right of first refusal was important to us. I don't remember it being a watershed negotiation, part of the negotiation, but my recollection is that we wanted the possibility to control what might happen on property that adjoins the property we were buying to develop. And also, this 40 acres gives us practical access to both Charles Road and Emerald Drive in the event we did ever want to use that 40-acre parcel for a county purpose.
Questions?
And if you decide to exercise the right of first refusal, the cost of acquisition would be $25,000, and we would have 90 days to get to closing on it.
Susan?
I'm wondering why this didn't come to committee.
It's a matter of the timing and the timing that we have to have in terms of response for a first right of refusal.
Okay, and there's not time to go back to committee. This has
Correct.
to decide today.
Correct. Again, it's one of those things that's kind of I talked with Grant. It is one of those things where it puts us in a bind as far as trying to make a decision right away. And again, I was not here at that time, and I know I actually talked with David when we were at the conferences trying to get some of the background on that. And it's really hard, for example, just knowing the back 40 with the wetlands and stuff like that, if or how we'd ever use or leverage that property. But just as Grant pointed out, you don't know until we actually have an opportunity to go through that process. So in essence, why we're bringing it forward is to say, well, if you want to, in fact, take the time, we should buy this property here, go through that process, and then we have that option. And if a year from now or 10 years from now, we decide that that's surplus, we can go back and obviously sell it, but we won't have a chance to buy it again unless the new property owner obviously offers to sell it again. So it's kind of a window of opportunity. It's short frame in terms of that, and it's kind of where we're at.
And it's typical of the right of first refusals of this era. This one was drafted in 1979. We have 10 days to either say yes or no, and then 90 days to close. So there really isn't much time to debate and discuss this. But as Ken pointed out, if we want to ever consider purchase of the rest of the 40 acres, we pretty much have to exercise this right of first refusal now, or the 40 acres won't be cleaned.
Dan?
The parcel we're talking about is just the one in yellow though, right?
That is correct.
We're still going to retain right of first refusal on the rest of them?
That is correct.
Correct.
Okay.
David?
Well, I guess, as Ken alluded to, he talked to me, and that's a long time ago, I guess, 18 years plus or whatever you're trying to recall, others did too. But the way I recall some of those negotiations, and Grant was there, was that Mr. Remy was selling with kind of an all or nothing. We weren't going to be able to buy a smaller tract for the Justice Center or a smaller piece for that. And so everything he owned in that location, plus the right to this, even though we had no intention of using it, you know, you're buying it. I guess the right came with it. And there's, as you look at the maps, there's 40 acres there that the county hasn't put anything on or used in any fashion yet, and that has access to Charles Road, which leads to Emerald Road.
Correct.
Dave?
And there's no requirements on this right of first refusal that prevents us from being able to sell it in the future anyways, correct?
That is correct.
Correct.
Linda?
Was the motion to exercise our right of first refusal? That is the motion, to exercise our right to purchase the property.
Correct.
At
So we don't,
$25,000.
Correct.
Yes.
so we don't have.
And we
to
have no
buy.
recommendation. We have no recommendation from any committee at this point?
Again, because of the timing, as Grant has said, we only have 10 days, so we were notified of this last week. So to meet that 10-day window, the first committee we could hit is this one right here, and that's why we're here.
So let's say we exercise the right, and so it says 25,000. If the person, the potential buyer, currently comes back and says, well, I want to buy it for 26,000, our max is 25. So they would,
Right,
they
the way
would have
that- yeah.
jumped the amount.
Yeah, it's not a bidding war. Now that there's an accepted
Right.
offer, we
And
have
that's
the
what I was
right.
curious about.
We have the right to say that we'll buy it for 25,000 and close on it for that amount.
Okay.
So it won't go up any higher than that.
Okay, so if they came back with 26,000, then it automatically.
No, it's based off
they
the
accepted,
accepted,
it'd
the
be
signed
done.
accepted offer.
Okay.
Susan?
I have very little experience with this particular property, and I'm wondering if, since we don't have recommendations from a committee, if there are members of this board that do have a recommendation or a thought that could guide us in this. I would appreciate it, frankly.
If I could, I'll just offer a little background. I know there was some research done in terms of, and David was correct, there was some interest, I guess, in that back 40 and some potential uses. And again, what it doesn't show, there's also an additional 40 that's behind the highway shop that we already do own. So again, there's quite a bit of property back there. And the only thing that we do know is that at one time there was consideration of a new government center being placed out there. There was some discussion at Parks to place soccer fields back there. So again, it's kind of hard to meet recommendation because it's been so long since this has been considered. And as we pointed out, there already is access off Charles Road to the other thing. So the road access we have, if you really need to have it. But again, is there a potential use that we have 40 years down from now? I don't know. And it's just one of those things, we're stuck in this window, and either we take that option and talk it through and then decide if we want to sell it, or we just say, hey, no, it doesn't fit, and we can move on. And that way we just know that most likely the other pieces, although you could consider other pieces, but if you're looking at the entire thing as a contiguous 40, if you say no, you're not going to have it, which I don't think any of us are going to lose sleep on that as that recommendation either, so.
Dave?
Yeah, I was going to say that there was, way back then in 2000, 2004 period, there was a location south of the highway shop as a potential location for senior center and human services, and that we know we've done the building, the old highway shop, so, you know, that's one of the spots, potential building spots that we probably won't use, and certainly not in the near future, if ever.
Dave Anigo.
As the resolution is written, we have several options. The red are the other choice words, and you match them up correctly. So as written, all black represents approval of exercising our rights and purchasing the property at that given dollar value, correct? And if somebody chooses to write a motion to not do that, they have to pick one of the other sets of red verbiage.
Motion would be to waive, release, and relinquish the rights to,
Oh, okay, so it's a two choice option.
Two options.
Okay.
yeah, exercise or not.
Linda?
Could I, so right now we have access on Duluth, County S. We have access on Charles Road to our back 40, whatever you want to call it. Charles Road, is that a town road? It's not just an easement, it's a road, correct?
Correct. Susan? I'm sorry, Kathy?
I have a question. Those other two properties before Charles is Brower and Lustilla. Do we also have first right of a refusal from them? I mean, that's also.
Yes, the
in the back.
area that's encompassed in blue, it includes the Brower, Lustilla, and Sternard parcels.
Yep.
Okay.
Mr. Chairman, point of order, is there already a motion on the table for this?
Correct.
To adopt this, yeah.
So I guess the thing that would be is you have a motion was to accept it as it was written in black. So right now you're saying that you would buy it. If you would like to change that, you say, well, I'd like to amend the motion to actually waive, release, and relinquish.
Who made the original motion?
I did,
Fisher.
and my motion is to exercise the option.
Okay, hearing no other comments, we'll take it to a vote.
Bottom line.
Yes, ready?
It's 14.
We go to the voter board.
It can go back.
Takes 14 votes.
It makes it easier to deal with the 40s. The rest of the process, that we can pick it up. Come on, you can hear me. There you go.
Failed, 13 yes, 8 no. So we will not be exercising.
Wait, my motion is to
Whoa,
exercise
that
is
failed.
13 yea.
Yeah.
It needs 14 to carry.
Oh, 14.
No,
Because it also is a 65-90 expenditure of non-budgeted funds, so it takes 2/3 vote.
just as a note for future, it would be nice to be reminded of those things.
Might make them change their vote.
Okay,
So, fail.
Okay.
before we move on.
Automatically the other way. I'm sorry.
Do you need a motion then? No.
We're going to move down to the ordinance before we finish the resolution. Ordinance 2018-17, amendment of Chapter 23, Door County Code. Mr. Fisher.
Thank you, Mr. Chairman. I'll make a motion to adopt ordinance number 2018-17, It is an amendment to Chapter 23, Door County Code. It is to bring our county code into alignment with the state changes to Chapter 23. And I believe Aaron is back here to answer any questions.
I'll second if you need a second.
Any questions on it? Aaron, do you want to add anything?
Sure. This is our Animal Waste and Agricultural Performance Standards Ordinance, and the changes are bringing the new targeted performance standards for sensitive areas, silurian bedrock areas, into county code. These are the changes that were adopted by the state in Chapter NR 151, effective July by the state. And this is a positive thing for Door County. It's what we need for groundwater protection.
David?
Basically got a curiosity question from a farmer as far as, these are basically in line with the state regulations. It's like we've done a number of RPC regulation changes where we brought our regulations in line with the state regulations. That's what we've done here. We have not added any additional regulations that the county is capable of doing.
No. We have not added anything. We've taken what the state has put into NR 151 and adopted that into our county code. Same as we've done with the other performance standards that we're working with right now.
And if I may, it's worth pointing out that if this ordinance is enacted, we will have exercised all of the authority and discretion we have under the performance standards and prohibitions and grafted those into our county code. So we've done as much as we can possibly do.
Susan?
I would just add, I guess especially for the newer members, that lobbying for rules specific to our karst region and the problems that it has with regard to groundwater is something that certainly Soil and Water and this county and citizens groups and even this body through legislative days has lobbied on behalf of for many, many years. This is like the final piece for us. So it's a good thing.
Anybody else? If not, we'll go to the voter board. That's passed, 21 yes, 0 no. Thank you. Okay. Back up to Resolution 2018-68, classification of employees for purposes of the Wisconsin retirement system under 40-061D.
Okay, I think this, talking with David, we're going to just take a short break. But before we take a short break, I'm just going to ask Scott Felt to come up. I just asked Scott to come up just to give, he's the administrator for Kewaunee County. I thought it'd be a little bit fair, at least to let the administration explain what they're experiencing, since we've been hearing that everything's falling apart. So what I'd like to do is have Scott come up. He can make a statement. He talked with their county board chair, and they can make a statement. And if you have a question for him, you can do that. But then what we'll do is we'll take a break, and then we'll get into, I guess, what we as staff would like to present. So Scott, maybe if you'd like to come up there or here, you can do either one. That way they can see you.
Thank you, Administrator Pavick, Mr. Chair, County Board Supervisors. I just want to give you what's the official position of Kewaunee County. Kewaunee County has reviewed the request because the same request was made from the employees in Kewaunee County as to taking the jailers, which are currently general employees, and trying to make them protected. And we had reviewed the various requests, and Kewaunee County has determined that the request would be denied, and the reason why is that the definition of what would be considered protected, that the radio operator jailers within Kewaunee County do not meet the criteria that would make them to be considered protected. We do not believe that they meet the 3 statutory requirements, and therefore the county has continued to affirm its position that jailers are considered to be general employees and not protected employees. From there, I guess I'll better to answer questions if there's questions. Yes, ma'am.
Are the jailers sworn-in deputies in Kewaunee?
They are sworn deputies, but as with anything, a sheriff can swear anyone as a deputy. Yes, ma'am.
Maybe I misheard you. Are you speaking just of the dispatch, so to speak, or are you speaking of all the jail employees?
All jailers are jailers and radio and 911 dispatchers. They're a joint position. Yes, ma'am.
Do these, similar to what you maybe have heard earlier, do they serve in the similar capacities, or can you parallel any of the capacities that were shared earlier with what the Door County deputies do here, as far as SWAT team or other?
There are jailers that do serve on SWAT. There are jailers that serve on various task forces and the like, yes. Yes, sir.
When they serve those other positions, are they paid differently?
No, sir, they are not, because actually the pay scale is the same. From a jailer to a patrol officer, the pay scale is the same.
So you run the same pay scale across the board?
Correct. Yes, sir.
When they serve on those positions, are they considered protected or non-protected then?
They are non-protected.
And the patrol officers that serve on those same positions are protected?
Yes, sir.
So there's a duality there that's going on that's different from one to the other?
Yes, sir.
Okay.
Yes.
What's your average length of employees? Like here, you know, it's about 10 years and some are less.
Are you talking in patrol or are you talking in jail?
In jail.
In jail, we've experienced recently a number of turnover, and I think that's part of the issue that you've been seeing. I think that turnover has been being experienced throughout the state to try to recruit people within law enforcement. And I know that there's an issue or a question as to what is the reason for that turnover, and there can be a large variety of things that can add to the turnover. The number of folks that have left the jail over the last 10 years have been from a variety of reasons of just retirement, of moving to a protected position, as well as just to do something different. So in that respect, I don't want to specifically say that protected is the reason why people are leaving. I can tell you that from a county standpoint, how we recruit our jailers, which we just recently changed, is that the criteria used to be that you had to be a law enforcement standard board certified person to therefore become a jailer dispatcher in Kewaunee County, which means that you have the exact same qualifications of someone who could go work out on patrol. So therefore, I don't think it's a stretch of the imagination that if I am working and ultimately I want to go to patrol, or I do not have the upward mobility within my county because no one from patrol is retiring, and I have the ability from my credentials to be able to move on, that they could do that. You have a number of jails throughout the state that do not require LESB certification. They just require a high school diploma and then to go through the requisite training.
Okay.
Yes, ma'am.
Do you need to bring in a patrol deputy to do investigations and arrests?
I'm sorry, say that again?
Do you need to bring in a patrol deputy?
You mean to make an arrest in the jail?
And to do investigations in the jail?
You do not, because if they're deputized, they have arrest powers. Yes, sir.
As you heard with our county, as a somewhat standard policy as far as getting road officers is kind of bring them into the jail system, get them through acclimated to that. If they wish to move forward, that's an option. How do you handle road officer new?
More often than not, what happens is it's internal advancement. Those that began in the jail then move up into patrol. So that's typical in Kewaunee County. We don't have, at least for as long as I've been here in the recent past, I don't believe that any road officer has been recruited from outside the department to go straight to the road. Yes, ma'am.
There's been a lot of talk about the court-appointed officers. Are they protected or not protected?
Court security from our contract is a protected officer, as is the school liaison.
I guess mine's the same with the jail administration or administrator.
Jail administrator is a command staff person, and so while, yes, they are protected, but all command staff is protected. Yes, sir.
A jail officer wishing to go on to being a road officer, how do you handle education as far as assisting them on getting whatever level of titles and that stuff they need?
I'm not exactly sure what you're asking, but I'll try my best. And then is currently you have the jailers that have the LESB certification. They've gone through academy. They've gone through all of the training in that respect. I know at times what has happened is there's been kind of usually a transition where an officer that they are kind of grooming for a patrol position will take on some shifts and therefore get something in that respect, but there's not a specific that there has to be some specific training. There's always your on-the-job training as time goes on. Yes, ma'am.
Maybe kind of a dumb question, but at what point then, if someone starts out in the jail, at what point do they become protected? When they go to the road? Is that just an automatic?
Yes, and at least currently from the county position is that a jailer dispatcher is a general position and not a protected position. If then a position opens up on patrol, then a recruitment process happens. With the interview, an officer is selected, and then when that person begins that position as a patrol officer, they are then considered a protected employee.
If someone is in, you said they're a deputy in the jail, and then they need to go on patrol for whatever reason it may be, or be involved in something else, are they given a choice? Because to say, like, I don't want to go on patrol because I'm not protected? And do people make that choice? Or are they directed by the sheriff that they have to, and then therefore they're in a position unprotected, sort of against their will?
Right. I can't think of a position, I can't think of an instance where a jailer has then been ordered to do a patrol shift. They're two separate jobs.
So they don't support the patrol, so that would be, yeah.
I mean, if there's something where it's an all hands on deck, but that instance hasn't come, so I can't really give you an answer to that question, ma'am. I'm sorry.
Thanks.
Yes, sir.
Another one for you.
No worries.
It was mentioned several times that if a jailer gets hurt on the job, or a road officer gets hurt on the job, substantially doing the same activity, that as a unprotected status, they would be no disability eligibility.
I'll answer the question regarding duty disability, but the premise I'll challenge slightly. Absolutely, the way it works is that a protected employee does have the duty disability benefit, and a general employee does not. As for being injured on doing essentially the same thing, I think that's again where you go back to the statutory definition, and the reason why they differentiate between the two is that because the statutes currently say that patrol is involved in active law enforcement from a ETF and a statutory standpoint, but from a jailer standpoint, they are not engaged in active law enforcement. So that's the differentiation there, and there can be all kinds of different opinions. Kewaunee County is just going with what the decisions were made at the state level, and the state level determines that jailers are not actively engaged in law enforcement.
But that applies to the type of disability. There is workman's comp and that stuff, correct?
Absolutely. All employees receive workman's comp. So the duty disability is something separate from workers' comp, but general employees do receive, as all employees, all county employees receive workers' compensation.
So as a protected status, it's an additional
Correct.
benefit.
Correct.
For essentially the same activity.
Again, I won't go with same activity only because of how the decision is made.
I understand.
Either one.
Oh, so what is your, like, average, what is your educational difference then between a jailer, especially the new ones that you're hiring, and somebody that you would hire for the road? And
I can go with what...
my other question is kind of like
Sure.
flexibility of people being able to move
Sure,
back and forth and do other things in the community.
I can give you, except for just recent recruitments, there was no difference from a qualification standpoint. Currently, we have changed the qualifications for a jailer that there no longer needs to be an LESB certification. And part of the rationale from the administration standpoint was that LESB certification isn't required to perform jailer dispatcher duties as shown throughout a number of other counties. Plus, in that respect, the feeling was that if they're not LESB certified, the likelihood of them then moving on to another patrol is less likely to happen because they don't have the certification to move. And we believe that the pay that we provide our jailer dispatchers is very very attractive. So therefore, the likelihood of a jailer leaving to go to another jail is unlikely.
Then, I mean, just to follow up on that then, because I've been thinking about the whole flexibility issue, because there's been talk of, someone who's working in the jail can be on the SWAT, qualified to be on the SWAT team, can go do patrol like snowmobiles and whatever else they do. And then also, we have a lot of festivals here, that's been mentioned. So your jail employees now, especially the ones that you're hiring now, are they qualified to go do these other type of duties or not?
That would be a determination of the sheriff as to how he would want to therefore assign those employees. Yes, ma'am.
How long has your county been unprotected?
Oh, no, I can't even think of how many years, but probably shortly after Act 10.
Act 10. Okay, what benefits do you think the county had, if any, and what are they?
Well, again, if you're talking from that standpoint, if you're talking specifically from a financial standpoint, at least prior to other contracts, general employees have to pay their full employee share of WRS. Also, general employees, prior to this current contract, were paying a higher percentage of health insurance premiums than what the protected were at that time, but that was due to union contract. Now, with the union contract the way it is, the protected pay the employee share of WRS, and they pay the same health insurance premium percentage as general employees. So in that respect, it's now pretty even. But there is also the retirement part, because ultimately at the retirement, there is a higher percentage that the employer pays. The employee still pays their portion, but a protected has a higher WRS percentage than a general employee and can retire sooner. Yes, sir.
You stated that your jailers in Kewanee can go out and do the same work as the patrol, and that they are not required to be law enforcement certified, which would include firearm training. So I can't imagine the sheriff is going to send those people on a SWAT team or to any situation and not even have a gun. That would be like almost suicide of sending an officer in to do a job, and he's not trained as a law enforcement and have firearm training to carry that weapon. Please.
Okay. Your first comment saying that doing the same duties as a patrol, again, I would take issue with that in that we do not put jailer dispatchers out on patrol. So when you talk about the same duties, that is not completely accurate. As for, from a SWAT standpoint, again, people have to apply and be accepted into SWAT, have to have the training to go out and do that, have to be able to carry a firearm, which all of our jailers are currently certified to carry a firearm. And so I guess I'm not sure the question, sir.
Well, then your new people you're hiring, you're not requiring them to be law enforcement certified.
Correct.
Well, then they don't have the qualification to carry a firearm.
Are you sure about that, sir?
Part of the law enforcement training is firearm training. I went through it.
Yeah, and I've gone through firearm training as well, but I'm law enforcement standard board certified.
So I guess the jailer could go ahead and do it on his own.
And again, what we're talking about and what we're trying to do is a transition as well, Supervisor, in the respect that with the new jail facility, you're going to see much more of a dichotomy then as well, that there's going to be patrol and there's going to be a much more focus on the separating out of the jailer and the dispatcher as well. But what we're talking about, again, from a percentage standpoint, because again, we have to talk about percentage. We have to talk about what the state has determined to be considered to be active law enforcement. And that's where I would have you refer to that as to, is there a sufficient amount of time in the estimation of this board that they believe that the jailer positions are actively engaged in law enforcement? And that's not for me to say, and nor would I say to this board. That, again, goes to the ETF decision, that goes to the state, and that goes to the decision of this board. I would never try to tell you what you should or shouldn't do. I just know what our county board has decided, and they do not believe that the jailer dispatchers meet the criteria that has been given by the state. Yes, ma'am.
Hi. Can you give us an idea as to what the makeup of your jail population is, daily numbers? How many of those are possibly from outside of Kewaunee County?
I wouldn't be able to give you that. I think the jail administrator would have been able to better answer those questions. Again, if we start to get into operations, then I'm going to show that I leave that to the professionals, and so I would be hesitant to try to answer that type of question.
Okay.
I'm sorry.
No, it's fine. Thank you for your honesty.
Well, I think one of the other questions I have is, okay, so if you have, we did a very intensive jail tour. Anyone who missed it missed a very good tour. But, so there's a population, I think that night, like 110, and 110, thank you, John. Yeah, 110 people, and there was one person in command, and we saw about 3 other people wandering around. Okay, so if you have a jailer, are they qualified to do the same things as someone who's law enforcement? I'm just I come from a nursing background, and I know that you can have an RN, and you can have an LPN, and you can have a, you know, a CNA. They can't do the same thing. So I am assuming that someone who is a jailer cannot do the same things that someone who's, you know, I forget all your acronyms, but that they're not, their duties aren't equal. So if you have that same population, do you need to have other people on staff? Does your staff increase because you have less qualified people, is I guess the simple way of putting it.
If we're going to get, I think what the better thing to do is, again, just to respect Scott, and I'm kind of putting him on the spot because he just literally drove up. Those general questions, I think we will cover those, and Grant's going to cover those, and I guess I'll cover that. I guess what I wanted to do is specifically give you the opportunity to ask him about their operations, because we've heard a lot of, unfortunately, negative things about their jail and operations, and while there's a perception of that, I think you also need to hear what their county board is saying and what Scott is doing as far as administration. So if we're going to focus on Kewaunee, I appreciate it, but give us an opportunity. We'll get into the detail of all that when Scott's done.
Yes.
Since Kewaunee County has changed to unprotected, did they ever try to bring it back?
There have been requests by the employees to bring it back to protected, and that's happened at least twice that I'm aware of. It could have happened more, and both times the county board's position has not changed, that the jailer dispatcher should remain general and not protected.
Was there a number associated of employees or percentage that were trying to bring it back?
It was brought forth by the sheriff and command staff on behalf of employees, as well as the command, I would assume the command staff themselves. Yes.
Did the sheriff in the situation in Kewaunee County, it sounds like it's been non-protective for a long time, so maybe that memory isn't there as far as the same sheriff being there, but did they feel that they were speaking on behalf of the staff that they should have protective services? Were they coming to you saying that they felt that it was 51% more law enforcement from their jailers? Or
Well,
what was their case?
I believe the sheriff has been in office for 12 years.
Okay.
So he's been there both before and after Act 10. And as for, there wasn't a petition with signed names or anything in that respect. It's just a preference or a demand isn't the right word. A request, I apologize. A request that the jailer dispatchers be returned to protective service as opposed to general.
I think I just have a hard time figuring out for this is that who is determining the 51%? Is it going to be the county board? Or is it going to be the sheriff who knows that a little bit better? I mean, I don't understand how that plays out.
The county, again, from the state, the individual counties get to determine the status of those employees, whether they are protected or whether they are general. And so therefore, it is not the sheriff that can make that determination, it is the county board that makes that determination.
Thank you.
All right. Thank you for your time.
Thank you.
Thank you.
Thank you.
Thanks, Scott.
All right, we're going to take a quick 7-minute, be back at noon.
Paybacks are held.
Did you bring lunch?